Your report finds that the prosecution was troubled by significant mismanagement, specifically the lack of supervision, which you point to, of the attorneys prosecuting the case, and the compressed schedule the prosecution was under. Did you in any way, shape, or form consider whether the failures to disclose evidence were due at least in part to lack of time or to a misinterpretation or misunderstanding of what these disclosure duties entailed?
I did. And I found and concluded that there were a number of failures to disclose impeachment information owing to the compressed schedule, the absence of effective supervision, and the fact that a decision was taken to permit FBI agents who were not schooled in Brady and Giglio to do the Brady-Giglio review. All of those occasions, which in my judgment were the product of the failure of management, came to light during the trial. They caused Judge Sullivan to have grave concerns about the credibility of the prosecution team, but they did come to light and the defense was able to use that information. Not so with respect to the 3 episodes about which we concluded that there was intentional concealment of exculpatory or impeachment information. None of those 3, in my judgment, was a product of the compressed time schedule or the management supervision failures.
So what was the motivation?
Prosecutors, plaintiffs' attorneys, defense attorneys for that matter, I happen to have served as all 3 in the course of my career, like to win. It's what we call contest living. We go into a case believing that our case is meritorious. We believe that our witnesses are telling us the truth. We do not want to have to undermine our case if it can possibly be avoided. I think that motive to win the case,
no matter what,
was the principal operative motive. I do not believe that any of the prosecutors, including Mr. Bottini and Mr. Gakey from Alaska, harbored a personal animus toward Senator Stevens. I don't believe that either of them sought fame and glory, and that's the reason they wanted to win the case. That's just not in their personalities, in my judgment. They did, however, want to win the case.
Thank you. Thank you, Mr. Chairman.
I just remind everybody listening, no matter how much a prosecutor might want to win, we still have the Brady case, and we have their responsibility to disclose exculpatory information. Prosecutor, and I can say this as one who was, a prosecutor has a unique position in the system. They're not just there to win. I understand what you're saying, wanting to win, but they're not just there to win. They're there to make sure that justice is done. Senator Cornyn, speaking of prosecutors, former Attorney General and Justice.
Mr. Schielke, the Constitution, the integrity of our adversarial system of justice, and the rules of professional responsibility that bind members of the bar, as these prosecutors were, all depend upon prosecutors observing some goal above and more fundamental than just a desire to win. Wouldn't you agree?
Absolutely.
Mr. Chairman, I'd ask, on behalf of Senator Murkowski, she has a statement that she'd ask unanimous consent to be put in the record, and I have one as well that I'd like to have put in the record.
Absolutely, and I told Senator Murkowski, of course, we would include anything she wanted.
Mr. Schielke, you have performed a profound public service. Thank you for that, and I know it continues here today. The thing that disturbs me so greatly is not that this prosecution involved a United States senator, because I doubt we would be having this hearing if it involved a citizen who was not a United States senator. And that disturbs me greatly, because I know the resources that you and the court have put into this investigation, and I doubt those sorts of resources, that time and that effort would be put into an investigation involving similar abuses involving the constitutional rights of other citizens accused of crimes, but whose rights were violated by the prosecutors by prosecutorial misconduct. Do you share those concerns?
To a degree. The Judge Sullivan, whom I know, would have done the same thing no matter who the defendant was.
And I appreciate that, and appreciate what Judge Sullivan has done here, particularly allowing the release of this report unredacted. And I hope the Office of Professional Responsibility report will be released to us in full in unredacted form so we can get to the bottom of this. Of course, one of the prosecutors in this case did not have an opportunity to respond to your report. Nicholas Marsh committed suicide, did he not?
He did, although his counsel was invited to submit a response and did so as a representative of Mr. Marsh's estate.
The Justice Department has told us that the Stevens case does not suggest a systemic problem with regards to prosecutors abusing their responsibilities to divulge exculpatory and other information required under Brady and Giglio. How are we to be, how could we possibly be satisfied with that representation? And how do we know? How does any citizen know that the Department of Justice won't abide by similar prosecutorial misconduct in the future?
First of all, I do not believe, on the basis of our investigation, that what happened in the Stevens case is representative of what happens in cases brought by the thousands across this country by the Department of Justice. Secondly, as Senator Leahy indicated at the outset, it was, of course, the Attorney General, Eric Holder, who moved that the Stevens case be dismissed with prejudice when he learned of a portion of the non-disclosure which had occurred in the case. Eric Holder did not shirk from that responsibility. I know Eric Holder both personally and professionally, and have for years. Likewise, his deputy, Jim Cole. Likewise, the Assistant Attorney General of the Criminal Division, Lanny Brewer. They are men of probity and integrity. And I do not believe the Stevens case, notwithstanding that the public should labor under the notion that what happened in the Stevens case happens as a matter of course.